Hello. Hello, my testing.
Save. Let's display this status in the slide.
Again, slide उसके. इकडे. वाढला वैभव.
Slide open this will be.
ഓ നമ്മള് വേണ്ട ഡിസ്പ്ലേ വേണ്ട. അല്ല നിങ്ങട്ടെ ഏത് ഫോണിൽ അയച്ചു കൊടുക്കണ്ട മോന്റെ ചോദിച്ചാ ഇത് വെബെക്സിന്റെ ഏത് രാധികന്റെ ഫോണുണ്ടോ? ഏത് ഫോണിലാ അയക്കണ്ടേ?
ഏത് ഫോണിലാ അയക്കേണ്ടത്? ഈ ഫോണിൽ നമ്പറില്ല. ശരി ശരി ഓക്കെ.
ഞാനും മീറ്റിംഗ് ചെയ്യണ്ട. അയ്യോ ഷർട്ട് ഇടാണ്ട് ഇവരെല്ലാം കണ്ട എന്റെ ഫോട്ടോ വന്ന് ഇടാ. അല്ല ഏത് ഫോണാ നിന്റെ വെച്ചിട്ട്? അതല്ല, നീ മോന്റെ ഫോർവേഡ് മോന്റെ ഫോൺ ഏതാ? പിന്നെ അതുമല്ല, ഓ അതാണ് ഞാനിത് പടം കണ്ട. അല്ല നീ ഇതിലൊക്കെ വെച്ചോ മോന്റെ. അല്ല നോക്കട്ടെ, വെയിറ്റ് അതല്ല, ഞാൻ അതിനയക്കല്ല അതിനയക്കില്ല. പോലെ അറിയാം. അത് നീ അയച്ചു, ഞാനിപ്പോ അയച്ചു കൊടുത്തില്ല. അതല്ല ഇപ്പൊ ഞാൻ നിനക്ക് അയച്ചെന്നെ രണ്ടാമത്തെ അല്ലേ?
Good evening, everyone. I think everyone can take a seat. Sorry that we started a little late, some technical glitches. I guess some things haven't changed in all these years in NALSAR. But my name is Suhasini. I am a 2009 pass out of NALSAR, and I'm also the program coordinator for the MK Nambyar SARC Center. I don't know how many of you know this, but the MK Nambyar SARC Center has been in existence in NALSAR for some years. But for whatever reason, it couldn't really live up to its full potential. And now this year we have, with some renewed efforts, we've relaunched the activities of the center. And this is our first flagship event, which we hope will kick off a series of things which we will do over the course of the next few years, which will benefit the students, the faculty, and the wider academic community outside and within NALSAR. First of all, I want to extend my warmest welcome on behalf of the MK Nambyar Center to Professor Mohan Gopal, who is our speaker for today. Sir has been so kind and has so kindly and graciously agreed to deliver this year's lecture. Sir, we are very, very excited to have you here and we can't wait to hear you. I won't take too long because I'm sure that everyone really wants to hear you and not me. I also want to extend a heartfelt welcome to Justice Ravindra Bhatt, who's the chair of the center. It's in fact Justice Bhatt who is support that has given us the confidence to go forward this year, and he's the one who's really made it possible for us to do all these things. So, sir, we're very grateful. Thank you so much for taking out the time. I also now want to thank the VC, Professor Krishna Deva Rao. Sir has been absolutely instrumental in organizing this event. Sir has been helpful from day one. Any small thing that we asked for was done within a minute. I don't think I've ever had such a smooth experience organizing any event. Thank you so much, sir. I just want to say a few words before I invite Professor Rao to come on stage. So Professor Rao was a very eminent academic. He has a career spanning over 3 decades. So just give me 2 minutes. Just give me 2 minutes. Very well. Sir doesn't want me to say anything. Please come.
It's a great pleasure to see this vibrant academic atmosphere in the NALSAR, and grateful that MK Nambyar SAR class center today is starting with MK Nambyar Memorial Lecture Series. Thanks to Professor Mohan Gopal and Justice Ravindra Bhatt. And I must acknowledge a lot of interest shown by KK Venugopal sir. I think some time ago when we approached, we were thinking about revival of the Sarkla Center. He has a clear vision. And I'll go back to the old memories. 2000, when we moved into this campus, 2 endowments were given. One is Junjunwala, because the first founder, Vice Chancellor, Umesh Chandra Banerjee, has immediately, before entering it, he asked Kaitan and Company, who was the founder, Junjunwala, you must give an endowment center. Second option, Professor Ranbir Singh, all of us, we requested KK Venugopal sir. We know how KK Venugopal and his father was part of the instrumental in developing a constitutional jurisprudence, MK Nambyar and KK Venugopal. And that was the, immediately after the Junjunwala, the major endowment was given by KK Venugopal sir. He gave for this Sark Hall Center and also for a comparative constitutional law center. And I'm grateful to you. I don't want to stand between all of you. Just one thought as another significant feature of the revival is association of our alumni. Alumni, those who have been all what you have seen, see Raji, Suhasini, Malavika, all of them have been working on how to restructure and beginning with this. And we know that role of the Constitution and the Supreme Court of India is what we have seen, transformative constitutionalism. The transformative constitutionalism, I don't think started in 2018. I will start with the post-emergency Indian Supreme Court and later on layers of, it depends upon who is there as not just only a Chief Justice of India and brother, sister judges. I think we are glad and we are awaiting to hear from Professor Mohan Gopal. And thanks for our alumni and Justice Ravindra Bhatt for the visualizing and coming out with this series, beginning with the lecture series and many more to happen. Thank you.
I would now invite Professor Vasanthi to come and say a few words. Professor Vasanthi is the director of the center. She's also been my teacher for many years, labor law and tax, and it was a pleasure for me. I don't know if ma'am shares the same opinion, but Professor Vasanthi, please.
Good evening. I'm largely here more as a vote of thanks to all of you, starting with, of course, Justice Bhatt, because it's after he's taken over as the chair. that we were actually able to put together a string of programs. All of you would have seen the fact that we're doing a constitutional law essay. We put out a call for papers, and we are looking at some serious research. It was his vision, and of course, the support that is offered by Malvika and Raji and Suhasini, that we could actually, take this forward. So it's really a vote of thanks. And of course, vote of thanks to Professor Gopal for graciously agreeing at quite short notice to give like a series of lectures. We all understand that this is not something that, you want to say from the top of your head. So it requires some engagement and taking time off from his other engagements. So it's really a heartfelt thanks to all of them for making this happen, because Malvika will know that this is something that we've been wanting to do for many, many years when she was a student here. And the fact that we're actually able to do it now is wonderful. And what Suhasini is saying, and what Professor Rao is also saying, that we want this to be a place where the alumni are coming back and are able to engage with, students now and create a environment, because really that's where we are looking forward to in the next 10, 15 years, that the alumni will come back to the university and we'll be able to take the university forward and deepen its engagement in research, in advocacy, and in several other areas. So I hope that this is only the first step in more activities that we want to do in coming years. And I really look forward to be able to do many more things. And I'm really seeing this as a coming together of students passed out and students yet to come. And so it's a wonderful feeling. I'm very happy to be here. And I hope all of you have a very exciting lecture ahead of you. So thank you again.
I would now invite Justice Bhatt to give the introductory remarks. Justice Bhatt needs no introduction. He is a judge, I think, who all of us as law students would be familiar with his judgments. I don't want to give a lengthy introduction except to say that Justice Bhatt's judgments have that quality that when you start reading them, you just know that they're authored by him. And I think that speaks a lot to his wide reach, both amongst the practicing legal community as well as the legal academicians. Sir, if I could just invite you to come and say a few words.
Thank you and good evening. Dr. Krishna Devarao, Vice Chancellor NALSAR, Professor Mohan Gopal, our eminent speaker, Dr. N. Vasanti, Suhasini Sen, distinguished guests, members of the faculty, ladies and gentlemen, and my dear students. A few words about Meloth Krishnan Nambyar is called for on this occasion, in whose memory this center has been endowed whilst we have gathered to hear an eminent speaker who will give us his views on the role of the Constitution in our democracy. Nambyar little knew that it was in his destiny to be written into the history books, so to say, and the lore of the Constitution as a beacon for generations to come. After having been called to the bar in the UK and enrolled as a lawyer later in India, where he commenced practice, he had occasion once to assist in a case before the Privy Council. He practiced for a decade in Mangalore, where he also became a public prosecutor before shifting his practice to the Madras High Court. On a personal aside, I remember having been told as a student that my father was a student those days, and it was popular for students, not just law students, but even students and the public to go and watch proceedings in the court. And Nambyar's performance was legendary. So my father remembered because he has passed, very vividly how he had witnessed Nambyar in action in the courts. Later, he shifted his practice to Madras High Court. He became a successful and sought-after counsel because of his expertise initially in criminal law, and he was frequently attending to death references across the high courts in many high courts in the country. He became one of the most famous counsel of his times, perhaps one of the early pioneers of constitutional interpretation when in 1950, in A.K. Gopalan's case, in the course of a challenge to preventive detention, he argued powerfully and very originally about the interconnectedness of fundamental rights and, most importantly, the centrality of the right to life, elaborating that procedure established by law should not receive a literal but expansive interpretation. This argument found resonance in Said Fazl Ali's dissenting opinion, which was very famous. The majority, however, rejected this approach, preferring the narrow interpretation. Thereafter, a few years later in Deepchand, he also participated in the arguments and led them, which resulted in a groundbreaking judgment where he successfully contended that any law which contravened fundamental rights after the enactment of the Constitution is stillborn or a nullity. It seems that this is taken for granted in view of the wording of section Article 13. And yet there was a controversy whether the doctrine of eclipse applied in the case of fundamental rights when a law conflicted with it. This judgment settled all those doubts, and any lingering ideas that laws are not a nullity but suffer eclipse by the concerned fundamental rights. Nambyar's articulation and Fazl Ali's dissent were vindicated in two separate judgments, first one in Cooper and later in Maneka Gandhi. The former did away with the compartmentalized viewing of fundamental rights. The latter accepted the contentions of the right under Article 21 that it cannot be cribbed by any procedure, but that laws must be reasonable and non-discriminatory. Nambyar also played a very pivotal role in the propounding of the basic structure doctrine, inspired by the lectures of a German academic, Dieter Konrad. This argument was first made in Golaknath. This argument, in fact, if you go back to Golaknath, was made in Golaknath, and the court records that the arguments are that the fundamental rights are a part of the basic structure of the Constitution and that the amending power can be exercised only to preserve rather than destroy the essence of those rights. These are some of the most celebrated cases that Nambyar argued in. His skill and mastery in formulating the arguments that he did truly set him apart as a man with remarkable foresight and vision about the kind of society which the nation aspired to be and the framers of the Constitution desired. Upon his death, the contemporary, then the Attorney General, described him as one of the greatest lawyers India has produced in the past and who are no more. Ever humble and modest in outlook, when of advanced age, he described himself by saying that I sit in the frail bark of my body and steer with all my might, but I find that I am neither the master of my vessel nor the captain of its decisive direction. For the momentum of its movement has often been gathered from the impact of the unknown. Nambyar passed on 18th December 1975. The legacy of Nambyar has been continued by the generous endowment of his equally illustrious son, K.K. Venugopal, till recently the Attorney General for India, who has also left an indelible mark on the jurisprudence of this nation by nearly countless contributions and interventions he made in several cases in these decades before the Supreme Court and the High Courts. His abiding concern for education is testified by the several endowments he has created in the memory of his father, which nurture scholarship and are meant to foster research and inquiry. We are grateful to Mr. Venugopal for his significant and thoughtful contribution. The Center has been fortunate to secure the consent of another eminent intellectual, whom I have the honor to introduce, Dr. G. Mohan Gopal, who has consented to deliver this series of lectures. He has experience in academia, judicial education, court management systems, and administration of securities law. enriched by his deep and abiding passion for the Constitution and its impact on society. Dr. Gopal holds a doctorate in law from Harvard University. He has the distinction of having taught in the Georgetown University, as well as the University of Singapore. He is a former director of the National Judicial Academy, set up by the Supreme Court of India, and a former Vice Chancellor of the National Law School of India University, Bengaluru. Dr. Gopal is currently an advocate in the Supreme Court of India, focusing on a few constitutional law cases. I can speak about my familiarity with him, about the many interactions we had over the last nearly 2 decades, and the numerous visits I made to Gopal as a judge from the Delhi High Court, sometimes as a participant and sometimes as a resource person. It would be an underestimation to say that he brought in a wonderful dynamism and gave a definite direction to judicial education and its ability to transform judges into reflecting upon values, the impact of courts' decisions on society, and the meaning of the Constitution in the everyday lives and duties of judges at all levels. I had written some more, but then I don't think I should stand in the way of the speech which Dr. Gopal is now going to deliver, except to kind of end this with another note that this event would not have been passed. Although I have been first. I have to start with the disclaimer that too much of credit is given to me for reviving or starting this center, restarting it, so to say. The credit really goes to the people who have moved behind this, and this is and then I give that entire credit to Dr. Vasanti, who has headed the center, from the department, and Suhasini, the newly minted Dr. Malvika Prasad, and Raji Gururaj, all of them alumni. With this introduction, I invite Dr. Gopal to deliver this first lecture in this edition of the Nambyar SARC Law Center for Comparative Law. Thank you.
Sorry? No. Okay, when I need it, I'll call you. Or can I not say it? Yes. But what about the internet?
Everything is there, sir. Everything. You can just call me. I'm not.
Read it like.
Should I put it in the page number first?
No, I'll get it. Thank you. I'd like to wish everyone a very good evening. And I'd like to begin by paying my respects to Honorable Justice Ravindra Bhatt, Professor Sri Krishna Dev Rao, and the colleagues here of the M.K. Nambyar Center. I'd like to express my gratitude to the center and to Justice Ravindra Bhatt in particular for the honor of and privilege of this invitation. I'm also grateful to Mr. K.K. Venugopal for giving me this opportunity to speak here today through this chair. I'd like to add my own words briefly of tribute to the late Sri Nambyar, who has been, as always, very succinctly but very meaningfully described by Justice Ravindra Bhatt. I also did not know him. But I've also grown up in Kerala, hearing about the legendary Mr. Nambyar as a lawyer and about his incredible skills. And the image that he evokes in my mind, which is very relevant to the young people here, is that I saw him as a person who broke barriers that one would think could not be broken. He went from being a government lawyer in a criminal court or a lawyer in the criminal court in a small Mofussil area to being a leading voice.
So just started. How much time it will take? 1 hour. 1 hour. Okay.
A leading voice of.
Come here. Okay. Actually, today morning I saw it. I saw that my car breaking. There's someone who will go to. I think today we share. I went for a.
So many lawyers who practice or judges who preside over local courts think that their world is very distinct. They operate in a different universe from the Supreme Court of India, or even from the universe of global constitutional jurisprudence. But he broke all those barriers and has established himself as a leading presence at all levels of the judicial system, also showing to us the essential interconnectivity between all these realms in the legal system, which we sometimes tend to ignore. I personally think that criminal law, as we know it today, modern criminal law, is not essentially about crime and punishment. It's about applying constitutional law to crime and punishment. And therefore, for me, it was very logical extension of a person who applied the Constitution in criminal courts to applying the Constitution in the Supreme Court in a much wider set of challenges. So he should inspire all of the young people here to break barriers that you think you now face and accept no limitations to your aspirations and your abilities. And the second thing is I carry with me is his extraordinary professionalism. You know, the amount of work he put into his arguments, the amount of study, the precision, and the amount of sheer sweat and tears he put into producing these fantastic arguments, I think is something that should again inspire all of us. I think it has been famously said that the genius is 99% perspiration and 1% inspiration. And I think he is living proof of that. So I add my own tribute to Mr. M.K. Nambyar. I also want to add a tribute to Mr. K.K. Venugopal, who, as Justice Bhatt said, is equally illustrious son of a illustrious father. And he's also made, as Justice Bhatt said, an indelible mark in our legal system and in our jurisprudence. I'd also like to pay a tribute to Justice Ravindra Bhatt, who, as he said, I've had the privilege and pleasure of knowing and working with over 2 decades. I had the pleasure also of appearing before him in the EWS case. where he wrote what I believe is one of the most courageous judgments, most historical dissents, where he struck down Justice Ravindra Bhatt, joined by Chief Justice Lalit, struck down the EWS amendment as unconstitutional. And I have no doubt that in course of time, this dissent will become one of the shining judgments of Indian courts. And I think I would like to pay tribute to him for his courage and his integrity and his erudition in delivering that judgment. I also tell students and the judicial academies I interact with that when I argued before him, I've always seen that. He said two things to me, if I may share this, which have stuck with me for a long time. He told me once that if a judge, and I'd like to believe that would also be true of lawyers, because he was a distinguished lawyer before that, knows the law, he will not be able to violate it. If he clearly knows the law, he will not be able to violate it. Now, that's an ethic, a very important ethic. And he makes the effort to know the law, and he's committed that if I understand the law, I will not violate the law as a judge or a lawyer. And the second thing he told me was that he was one of the early judges who started using laptops to do his judgments. And his method, his craft of judging is such. He once told me that, but I saw that in action when I appeared before him, and he said, even when I'm walking to my podium to deliver the judgment, I really don't know where my logic and my argument will lead me, to what decision, because he's purely following the law and the logic, and he's not working backwards from a result. And he said, sometimes as I'm about to deliver it, I may think, yeah, there's some slight adjustment I need to make to the logic, not to the result. And I actually once had a High Court judge from Australia who told me the same thing. He said, look, I am not interested in the outcome of the cases that come before me. I'm only interested in the principle of law. The lawyer's challenge is to persuade me that a principle of law is correct, which when applied to the facts of his case result in a favorable outcome for him. That's his challenge. But I am indifferent to the outcome. I want simply to understand and apply the principle of law. So I think I saw this in action when I argued before him, because he was very transparent and very honest. Whatever view he had about the matter, he would openly say in open court to everyone, so that you had the chance to react, respond, to rebut. And you could see transparently how his understanding of the law was, based on the arguments, his own understanding and his understanding of the arguments was evolving. And I think that was extremely valuable. And I think something that I share in judicial academies, because it's a model that judges should follow. So I'd like to say it's a real privilege and an honor to be in his presence and to have this opportunity to speak with all of you in his presence and hopefully have a conversation. I'd also like to pay a tribute to the Vice Chancellor, who also I've known for many years. And he's a proven leader of educational institutions and has made huge contributions to our legal education. And I'd like to pay tribute to him and say it's an honor to be here in his presence. Let me also thank Suhasini, Malavika, and Raji, and all the young team of bright young lawyers I've been talking with over the last few days about the presentation that I'm about to make. So with this long alap, let me turn to my topic. I'll turn to this topic by, I'll explain to you what I want to explore by discussing with you two cases. And that will bring out the question that's in my mind and should be in your mind. But before I do that, I want to share with you some figures and statistics as a background, which will explain why we chose the topic of the struggle for democracy. And here I'd like to request Kshetrajna to kindly take us to, take us to page, to the definition. No, we want to go to the other one. The other, this is the one. See, what is the state of our democracy? What is the state of our Indian democracy? That's the question which I'm trying to discuss as a background to what we're discussing here. And if you look at okay, right. No, I got it. So there is a set of researchers who work on regimes of the world, that's ROW, and they collect data and look at what kind of regimes are prevalent in the world. And they analyze democracy. So they have divided democracy into one set of people assess democracy on the basis of a continuum, more and less democracy. But these people have divided it into 4 categories. 2 categories of autocracy and 2 categories of democracy. Okay. Now let's start with the definitions here. Closed autocracy, citizens where countries or polities where citizens do not have the right to choose either the chief executive of the government or the legislature through multi-party elections. So they're closed autocracy. Electoral autocracies are citizens where the citizens have the right to choose the chief executive and the legislature through multi-party elections, but they lack some freedoms, such as the freedoms of association or expressions that make the elections meaningful, free, and fair. So there are countries where there are elections, but the elections are basically not free and fair. Then we have 2 types of democracy, according to them. Electoral democracy, where citizens have the right to choose the chief executive and the legislature in meaningful, free, and fair and multi-party elections. They do not have all the elements of democracy, but certainly their chief executives are selected through free and fair elections. That's an electoral democracy. And a liberal democracy is a democracy where citizens enjoy individual and minority rights, are equal before the law, and the actions of the executive are constrained by the legislative and the courts. So there is check on the executive. And so it's a full-fledged, all the parameters of democracy that we imagine are present. Now we turn to the other one, Kshetrajna. Now this is from Regimes of the World. There is an organization called, Varieties of Democracy, or VDEM. They have a very good website. It is located in the University of Gothenburg in Sweden. It's a public university, so it's a public research center. And so if we go to their website and we look at page 17, and you enlarge it a little bit, first shrink it, and then we can see that they have, you can shrink it a little more, bring it down. They've organized, they've organized all the countries into these four categories: liberal democracy, electoral democracy, electoral autocracy, and closed autocracy. They have data on nearly 200 countries. And they have data, they have the largest data set in the world on democracies. They have data from around the 18th century to the current date, all compiled and put together. So it's a massive database on the basis of which they're analyzing nearly 200 countries. And the big picture is they say roughly half the countries are democratic, half are autocratic. But if you take the population of the world, 70% live in autocracies and 30% live in democracies, of which some 20% live in liberal democracies and 10% live in electoral democracies. This is the big picture. So in other words, there's a big struggle for democracy going on in the world. There is progress towards that, but there are still autocracies extremely strong all across the world. Now, if you look at this third column, which is electoral autocracy, you will find there that India is now ranked as an electoral autocracy. For all these years, India was ranked as an electoral democracy, meaning we had free and fair elections, but we did not have many of the other aspects of democracy. And so we were an electoral democracy, not a full-fledged liberal democracy. We have now slipped to being an electoral, an electoral autocracy. So let's move to page, 19, yeah. Page 19. So here they say trends of regime change. The wave of autocratization is notable. Autocratization is going on in 42 countries, home to 2.8 billion people, or 35% of the world's population. India, with 18% of the world's population, accounts for about half of the population living in autocratizing countries. Whereas countries that have slipped from democracy to autocracy. So we say we are the mother of democracy, the greatest democracy in the world. Maybe right, I'm not saying it's wrong, but there is another view. And that view comes from very credible, objective international researchers who say that India is no longer a democracy, India is an autocracy. So if you look at the map, you can see overall the spread, and you can see that India is now colored as an autocracy, but an electoral autocracy, as against China, which is a closed autocracy. And then we go to page 24 and 25. Let's go, where we say 8 out of 10 countries in this group were democracies before the start of autocratization. Democracy broke down in 6 of these 8 cases. Those 6 are the Comoros, Hungary, India, Mauritius, Nicaragua, and Serbia. And then they talk of Greece and Poland remain democracies. Of these 10 countries they're discussing there, only Greece and Poland remain democracies. Then on page 25, they discuss India, and then we'll end with this slide. India's process of autocratization begins in earnest from 2008. 2008, so 6 years before any regime change. So it's not really associated with any particular political party or any particular person coming to power. The autocratization begins in 2008 and characteristically proceeded, according to them, and characteristically proceeded in the incremental, slow-moving fashion of the third wave. That's the third wave of autocratization they discuss separately. Those of you are interested, this is v-dem.net. You can find it and read the whole report. This is the 2024 report. Over the years, India's autocratization process has been well documented, including gradual but substantial deterioration of freedom of expression, compromising independence of the media, crackdowns on social media, harassments of journalists critical of the government, as well as attacks on civil society and intimidation of the opposition. All of this were present at the union level and the state level, regardless of the political flag, since 2008. And the ruling anti-pluralist, Hindu nationalist, Bharatiya Janata Party with Prime Minister Modi at the helm has, for example, used laws on sedition, defamation, and counter-terrorism to silence critics. The BJP government undermined the constitution's commitment to secularism by amending UAPA, which was, of course, introduced by the Congress government. The Modi-led government also continues to suppress the freedom of religion. They're talking of what's happening now, but it started in 2008, of religion, freedom of religion rights, intimidation of political opponents, and people protesting government policies, as well as silencing of dissent in academia, right, are now prevalent. India dropped down to electoral autocracy in 2018 and remains in this category by the end of 2023, which means 10 years from 2008 to 2018 is when India slipped into an autocracy. Okay, so now with this background, we can say there is a very credible view globally. We may or may not accept it, but there is a very credible view globally that we have lost our democracy already. Not that we are in the process of losing it, we've lost it. And this report also says usually democracies that lose their democracy and autocratize find it very difficult to come back. And so for all of you young people, this is a very serious issue. Because as I will discuss shortly, democracy means, demos means people and kratos means power. It means that power must be in the hands of people. So all of us have some sense of Swaraj, which is what the freedom fight was all about. That's democracy, and we've lost that. So now the main focus here is, you can see a lot of these reasons for losing democracy that they list as outside observers have to do with the law. Violation of the law, lack of enforcement of the law, lack of protection of rights. So then we have to ask ourselves, do we have, as lawyers, a share of responsibility in losing the democracy that our parents and my parents and Justice Bhatt's parents and grandparents' generation and Professor Krishnadev Rao's parents and grandparents' generation won for us through great sacrifice? It's not just the law, not just the legal system. There are many factors, but we have to ask ourselves, since most of the responsibility for the laws is being put on the failures of the legal system to protect rights and uphold the rule of law, we have to ask ourselves, did we fail? And if so, how did we fail? And where did we fail? Was it our constitution? Or was it the judicial system, the courts, that interpret the constitution? The meaning of the word interpret is give me meaning to, or explain the meaning. That's what, if you look at the dictionary, you'll find interpret means explain the meaning. So there is the constitution, and there are courts that define, have a monopoly and the last word over defining and explaining what is the meaning of the constitution. So either the constitution is wrong, or the meanings that have been given to the constitution are wrong and have weakened democracy. So I turn, as you can see in this little brochure, as I often do, to Dr. Ambedkar's words, however good a constitution may be. You all know these words, but it's worth reading and reminding ourselves, because we are the people who work the constitution, our profession. Just like doctors are the ones who work the health system, we are the people who work the constitution. Dr. Ambedkar says, however good a constitution may be, it is sure to turn out bad, because those who are called to work it happen to be a bad lot. However bad a constitution may be, it may turn out to be good if those who are called to work it happen to be a good lot. The Constitution can provide only the organs of state, such as the legislature, the executive, and the judiciary. The factors on which the working of those organs of the state depends are the people. The people, that's us. And the political parties, they're also a bunch of people. They will set up as their instruments to carry out their wishes and their politics. So did we fail our constitution? Did our constitution fail us? We need to understand this. Why? Because we have to correct this. We have to regain our democracy. And we have to understand why we lost it. And we have to understand how we can regain it. And that's the purpose of these three lectures over these 2 days, to explore this question. Are we responsible? I'm not saying we are. Are we responsible or not? How do we think about that? What conclusion should we come to? And if we find that we are responsible, the first question is, have we lost our democracy? I think there is a consensus amongst a significant number of people that we have lost. They will agree with this and say we have lost our democracy. Or it's in shreds. It's really at a level where we cannot say we are a democracy anymore. A lot of people would have that opinion. But assuming that, then we have to ask, were we responsible? And if so, how? And then more importantly, we have to develop a strategy on how to win it back. So for that purpose, I'll do two things. One is I will give you an example of the approach I am proposing to use to answer this question. There are many different approaches we can take. How do we find, let's assume we've lost the democracy. We've lost our democracy. Because we can't take a risk of ignoring that. Let's assume we've lost it. How do we know whether we are responsible for it as lawyers and where we failed? What's the methodology to answer that question? So the methodology I'm taking, I'll explain to you. It has two parts. One is a methodology. Second is I will have to clear up some fundamental concepts very quickly before I proceed further. But the methodology I can demonstrate to you by using two cases. When should I, what time should I stop? Because 7:30, is it okay? Is that okay with everyone, 7:30? We must do it democratically. Is there anyone has a problem with that? Are you able to stay? Okay. What I'm planning to do, I'll explain to you at the end of this, what I'll do today and then next 2 days. Today, I want to explore this methodology of how do you answer this question, whether on the question whether the legal system is responsible for the loss of democracy, and if so, how? Then I'll come to what I'll do do tomorrow. So one case is Chempakam Dorairajan, and the other is A.K. Gopalan. A.K. Gopalan I picked because M.K. Nambyar, that's, in fact, once I think Mr. Nambyar said somewhere that A.K. Gopalan told him, they're kind of distant relatives, A.K. Gopalan and M.K. Nambyar. And A.K. Gopalan apparently told him, Mr. Nambyar, you made me a famous political leader and I made you a famous lawyer. And so it was a win-win situation for both of them. So I picked that example. But Chempakam Dorairajan, right? Very briefly, both these cases, very briefly, because I want to look at these two cases from a different perspective. Chempakam Dorairajan, as you know, is a case where the British colonial rulers of Madras province put in place a scheme responding to a strong non-Brahmin movement demanding representation for non-Brahmins, which grew in strength, Justice Party and so on. They put in place a scheme where they limited the number of seats in engineering and medical colleges according to communities. They gave only 2 seats for Brahmins, 6 seats for non-Brahmin Hindus, and some seats for women. It's only when I became a law student that I realized that I may have been a beneficiary of the scheme. Because my mother studied in the Madras Medical College as a woman, and I know there are 2 other women who studied there who were her classmates. And I wonder, my mother never told me or had reason to tell me, not to discuss how she got admission there and became a doctor. But I think that maybe if there was not a set aside for women, none of these women would have made it. And because she became a doctor and so on, that had a very positive influence on me as a profession, having a professional mother was for me. I'm not saying for everyone, I'm not generalizing. For me, was a very positive thing. And so I kind of benefited from this British colonial order, at least as far as it set aside seats for women. So they set aside these seats. This continued. During this period, the people whose numbers were drastically reduced to 2 seats in the medical college, each seat perhaps, I don't know the exact number, 4 medical colleges, 4 engineering colleges or so. They had no remedy because it was it was an autocracy, so they had no remedy. They had to accept it. There was no right to equality in the Government of India Act, although, as Justice Butt reminded me, the Government of India Act did recognize the existence of social discrimination, again in response to these popular movements. But there was no right to equality, there was no Article 32, there was no remedy, no writ petition, no public interest litigation, nothing. So you just have to accept it. So they accepted it. Meanwhile, these Dalits and the marginalized sections fighting, handful of their leaders end up in the Constituent Assembly. Although the Congress and the left got Ambedkar defeated in Maharashtra, in West Bengal, one Mr. Mandal gave up his seat so that Dr. Ambedkar could come into the Constituent Assembly. And he and a small group of people came to the Constituent Assembly, fought very hard, tirelessly, and got Articles 14, 15, 16 written into the Constitution. For what purpose? To ensure that the privileged section, the monopoly of the privileged sections would be constrained or eroded or dismantled by these provisions of rights to equality. That's why they put it there, so that more opportunities would open up for the marginalized sections. And why did Dr. Ambedkar do it in 1930? When he addressed the first roundtable conference in London, Dr. Ambedkar made a prediction which has come true. He said, when the British leave India, India will be ruled by an oligarchy, a caste oligarchy. And today, when we look around, by coincidence, the power in the union is in the hands of 4 communities. And you go to every state, you'll find 2 or 3 communities having an oligarchy of power, with whichever background they come from. But there are 2 or 3 communities that really have the bulk of opportunities and power and positions and wealth in media, academia, everywhere. Oligarchy, right? Rule of a few. So he predicted this. And he also demanded in the roundtable conference that the only antidote to oligarchy being representative democracy, the depressed classes of India want not only responsible government, that is electoral democracy, but we want representative democracy based on due and adequate representation of all communities, not classes, not castes, but all communities. This was Dr. Ambedkar's demand in the Roundtable Conference. Accordingly, for that purpose, 14, 15, 16 came into the Constitution in their current form. So this Constitution got adopted. Within days of the Constitution being adopted, the Brahmins who were restricted in terms of their admission to these colleges saw this as an instrument used to protect the Brahmins, not the depressed classes. Because they got Article 226 and 32, they got the right to equality, they got Article 15 saying no discrimination. And what was the first use made by the Indian judiciary of 14, 15, and 16 was to protect the Brahmins. So in a sense, those who are working the Constitution the lawyers and the judges, those who are working the Constitution, they flipped 15. They turned it around from being an instrument to create representative democracy. You gave 2 seats to Brahmins because that was the proportion to the population that they should have had, according to the authorities. Other seats should go to other communities so that all communities will have, according to Dr. Ambedkar's principle, due and adequate representation. So constitutional provisions introduced for that purpose got flipped to be used to protect the privileged rather than open up opportunities for those who are marginalized. So we see here an example of a result that was completely unexpected, where an instrument for social revolution was inverted as an instrument for counter-revolution. And for this purpose, a doctrine of reverse discrimination was established in India without using that term well before 1978, when the Bakke case in the United States established the principle of reverse discrimination. Chempakam Dorairajan basically established the principle of reverse discrimination and the principle and the right to equality being a shield against reverse discrimination much before the Bakke case. And that's the doctrine that we get from that decision. And even though the Constitution could be amended to reverse the order of the court, we have not been able to reverse that doctrine. It still prevails to this day, the doctrine that reverse discrimination, that equality clause must protect against reverse discrimination. Now, now the question is, where does this doctrine come from? And my argument is that it comes from society. And we'll go into that. It comes from society. How does it come from society? How do we find the roots of this doctrine of reverse discrimination, of equality being a shield against reverse discrimination for the elite and the powerful, the privileged? How did it come from our society? Was it the fault of the Constitution? Could it have been drafted in a different way? Or was it the fault of those who worked it? Similarly, if you look at A.K. Gopalan, we know the facts of the case. A.K. Gopalan arrested, kept in jail, re-arrested, and re-arrested, and the court refuses to strike down his preventive detention, being in jail for no reason other than his political work, and then lays down. The question is, what is the doctrine laid down by A.K. Gopalan? Whatever the decision may have been, whether he won or lost, and I find that doctrine laid down by Patanjali Shastri, which he says, where he says the following: the responsibility for the security of the state and the maintenance of public order having been laid on the executive government, it must naturally be left to that government to exercise the power of preventive detention whenever they think the occasion demands it. Now, if you take out the word preventive detention and you say that the executive must be given the power to take away liberty, because the argument was it was a violation of 19, to violate 19, to violate 21, whenever the security of the state demanded it, remains a doctrine which is accepted by courts even today. There it was preventive detention. Today it may be UAPA, it may be something else. But what Patanjali Shastri Justice said is that the responsibility for the security of the state and maintenance of public order, etc., having been laid on the executive government, it must naturally be left to that government to exercise the power of preventive detention whenever they think the occasion demands it, to violate Article 19 and 21 whenever they think the occasion demands it. So an abdication of the function of the judiciary as a guardian of fundamental rights. Justice D. Desai, in his 117th report of the Law Commission on judicial officers training, he clearly says that the challenge faced by the judiciary, and that's why he recommended the establishment of judicial academies. He said the Indian judiciary had to face an extraordinary challenge to transform overnight from being, these are his words, an extension of the law and order machinery, to becoming a sentinel on the qui vive of fundamental rights, a guardian of fundamental rights, a complete reversal of the roles, from being a part of the executive, yielding to the executive, being concerned about the executive, helping the government, executive protect, to do its work, to being a hawk that watches over the interests of the rights of the people, to stop the executive, to restrain the executive from violating the rights of the people, especially the marginalized and the defenseless. That's how Justice D. Desai saw the challenge. But no one has been able to overthrow the doctrine that Justice Patanjali Shastri laid down. It's a very powerful document. Now, the question I want to ask is, why did these two doctrines stick? Why have they survived so long? That equality, also, that's why they say unequals cannot be treated as equals. This is all a sort of coded way of saying, don't act against the privileged. Why did that principle of reverse discrimination stick so long? Why did the principle that once the interest of national security is claimed by the executive, the judiciary must shut down and yield? Unless there is some clear mala fide, in exceptional cases, there is something egregious. So now, for example, instead of 19 protecting our rights, where we are now is the government comes up with any claim, any government, state government, national government, whatever flag, whatever party, it's been going on for a long time now. They come up with an allegation, they arrest you, and the relief that you can get from the courts is no longer that your arrest will be struck down, quashed, and you'll be let free. Very rarely, it happens, but very rarely. But the relief has now been demoted to being given bail after several months. So the government arrests you, throws you into jail. Then several months later, you start at the bottom, go to every single level of the court, and you work your way up to the Supreme Court. And finally, heroically, the Supreme Court gives you bail. Meanwhile, you've spent months in jail. So our level of protection, judicial protection, legal protection of freedom has degraded to the point where we have no protection against arrest if the claim of national security is made, and prolonged detention. The best we can hope is that after prolonged detention, at some point of time, we may get bail. And sometimes even that is denied, like happened with Father Stan Swami, who begged the court, I will die. Nothing so far. To this day, there is nothing produced against him, except that he was offering legal aid to prisoners who are tribals and who are innocent tribals who are under trials. And for that, he was arrested, sent to a COVID-filled jail. And all of this was done not by thugs coming in the middle of the night. All actions taken to arrest stand Swami and take him to his death were done by law graduates. The prosecutors, the magistrates, the high court judges, the lawyers in the high court. So what's the point of legal education if we cannot protect that man? Where are we today? So this is the question. So the last part, which I wanted, then we can have a few questions, is for today. I want to set out these basic things, the basic question, what are we trying to explore? So I've given you an example. How can such doctrines come out from a court? And how can they sustain and survive and draw strength for so long across many generations of judges, many generations of lawyers, many generations of law teachers? We all know and admire Professor Bakshi for his brilliant thinking and writing, extraordinarily brilliant thinking and writing. He's spent his whole life, and I don't think it's a waste. I think he's contributed enormously to our knowledge and understanding. But at the end of the day, none of this is having an effect in terms of protecting our freedom and liberty. So this is what we want to explore. Now, in exploring this, there are 3 or 4 ideas that I need to discuss with you just so that we are on the same page, and then we'll conclude for today, and then we'll meet tomorrow. The first idea that I want to explore is, let's go through these words: the Constitution, democracy, and courts, and make sure we are on the same page that when we understand these words. Now, what is the Constitution? This is a question that I have struggled with theoretically for a long time. And the definition I have now found sort of acceptable to me is that a constitution is not, so if you normally ask people, you'll say it's a Grundnorm, it's the document of the highest law, and that's a sort of a hierarchical view that it has higher authority than statutory law, more majority to change it, and it contains Grundnorms. It governs, it's a document that sets out the governance structures, but these are its functions. But what is it? And if you take the words of the Constitution, maybe we can understand something from it. If you take the preamble's beginning, it says, "We the people of India, having solemnly resolved to constitute India into a sovereign socialist democratic republic." Having solemnly resolved to constitute India, not having constituted India. So the preamble says it's a proclamation of intent by we the people that we have decided to constitute something. Constitute means create something, bring something together that doesn't exist. We the people of India. So India is used in 2 ways. One may be legalistic. We the people of India, meaning India Independence Act, where does the power come from the Constituent Assembly? We the people of India. From an international law point of view, where is the power coming from? So that's the India that, the British India and the princely states and so on. We the people of this polity, this territory. We are proclaiming something very significant, that we are going to create a new country, which doesn't exist now. A sovereign, socialist, secular, democratic republic. Socialist and secular have been added later. But we're going to create a democratic country because we've never had democracy before. Till 1950, there was no right to equality. There was no right to liberty ever under any dispensation in this country, enforceable, which a common person could access. So we want to create a democracy, a democratic republic. to secure to ourselves justice, social, economic, and political, liberty, equality, fraternity, and dignity. So we know that this is a proclamation, unquestionably. What does that tell us? It tells us it's an announcement of the launch of a struggle. So for me, I read the word Constitution of India as a present continuous verb. The process of creation of India, the story of creation of India. What is going on in this room? We are constituting a committee. What is going on here? What's going on here is the constitution of a committee. Right. So the Constitution of India means the story of constituting India when read with that proclamation in the preamble. Starting in 1950 and still going on. A massive struggle by today the largest population in the world. Why was that struggle necessary? Because we were not a democracy. We are not a democracy. And frankly, it's a great achievement that we even became an electoral democracy. Not because of, but in spite of the efforts of the legal community. One generation of legal community brought us freedom. The next generation of the legal community is fighting it. By and large, that's a conclusion that emerges from my analysis. And we've got to correct that. So I understand the Constitution, therefore, as a site, S-I-T-E, a site of struggle. Our Constitution, not all constitutions. Our Constitution, the Indian Constitution, is a site of struggle. It's a declaration, a proclamation of the commencement of a struggle, and then it provides a framework for that struggle to take place. That struggle has been taking place for centuries all over the place in society. But the Constitution provides a framework within which, not exclusively, we can wage this struggle in a peaceful manner, a non-violent manner, in a rational manner, to bring about this transformation into a democratic society, and a democratic polity. So when I say Constitution, I mean the role of the Constitution as a site of struggle. So if it's a site of struggle for democracy, that site is not working well if we are losing democracy. Whose fault is it? And then we see, we understand, I mentioned already democracy, to me, we have to understand it as demos and kratos. It's not electoral democracy is only one part of it. But socially, economically, politically, power must rest with the people. Demos must hold kratos. Kratos is power. That is Swaraj. That is a dream. I've read a piece by K.A. Abbas, the old great filmmaker, about Gandhiji visiting a small village, where he describes Swaraj to very poor people, weavers. And one woman took her entire earnings, which was all just entire material possessions, a few beads and so on that she had, jewelry, and gave it to Gandhi. And he said, "This is for Swaraj. Not for you, it's for Swaraj." Then she asked him, "Kab milega ye Swaraj? Will we get it in my lifetime?" Because she wanted the right to self-government, not from a utilitarian point of view. It is deontological. It's an end in itself. And so our struggle is to establish Swaraj, which is democracy. And that struggle is faltering, has faltered. We've lost whatever democracy that we had, which we never had before 1947 and 1950. What little gains we made, we have been pushed back. So that's my understanding of what the Constitution is. The Constitution as a site of struggle. And now we are examining how that struggle is going and what is the role of the of the courts in that struggle. Now there I come in and say, was there a different way in which Champakam Durarajan the court could have, the full court of the Supreme Court could have interpreted the Constitution, Article 15? And I'm saying, yes, they can. They could have interpreted Article 15 based on the Constituent Assembly debates. I think A.K. Gopal and also they considered the issue, can you refer to Constituent Assembly debates and advisory committee reports and all that? But they could have, see, if they say yes, who's there to stop them? They're the Supreme Court, right? So if they had been sensitive to the Constitution as a site of struggle, to the struggle that created 14, 15, and 16, it didn't come from abroad, it came from the blood and sweat and tears of poor people. Then they could have interpreted 15 and said, that 14, 15, and 16, as Justice Butt said in his dissenting judgment about 16, can only be used to advance representation in the interests of the marginalized sections. For the others, we'll give you any assistance you want because you are unable to get these seats, not because society has closed its doors on you, but because you have not made use of the opportunities that are available to you. These set-asides are for people, including women, for whom society has closed their doors, the doors for them. So the Durarajan, Champakam Durarajan judgment could have taken a different view and set the Constitution struggle on a different path, saying this is a struggle to empower the marginalized, not to build walls of defense walls for the privileged against this democratic transformation. Likewise, the A.K. Gopal and court could have accepted the arguments of M.K. Nambyar, should have accepted the arguments of M.K. Nambyar, and not given us the doctrine that national security, a claim of national security, is adequate to violate fundamental rights to liberty. So an alternate view was possible, but did not come because they did not, the court, those who were working the Constitution, giving meaning to the Constitution, did not understand the nature of the Constitution as a site of struggle, democratic struggle, and therefore gave it the wrong meaning as an instrument to protect privilege. Now, this is where I want to, Kshetrajna, can we switch to this last thing? No, next page. Second, middle, yeah, this one. Now, this is a passage from Justice Butt's judgment. I'm not putting this because he's here. I've cite this wherever I go. This is in Prithviraj Chauhan. And you must read it carefully. More people need to do. This is, to my knowledge, the only instance that I am aware of where in India a judge or a court has taken a different view of the Constitution. So Justice Butt, and it's worth spending a couple of minutes reading that, the Constitution of India is described variously as a charter of governance of the Republic, as a delineation of the powers of the state in its various manifestations vis-a-vis inalienable liberties, and a document delimiting the rights and responsibilities of the Union and its constituent states. It is more. It is all that. 2/3 of the Constitution is administrative. It's a governance institution, but that's not really the Constitution. The Constitution is a process of constituting, creating a country. A country is created by a set of norms. So I was discussing yesterday and saying that much of what passes for constitutional law today is administrative law. It's not really constitutional law. To me, a constitutional issue is always a normative issue, where we're looking at not just any normative issue, but the fundamental norms that constitute society, the permanent norms which are necessary for that polity and that country to exist. That is a constitutional issue. That's a concern of the Constitution. Therefore, Justice Butt says, yes, of course, you may put into the Constitution administrative provisions which you do not want should be easily changed and routinely changed to protect them. Fine, no problem with that. But that's not really the essence of the Constitution. It's normative. So Justice Butt says it is more. It is also a pact between people about the relationships that they guarantee to each other. Apart from the guarantee of liberties vis-a-vis the state. So this is a very important idea, that the Constitution is a compact where people guarantee how they will treat each other based on equality, dignity, liberty, and so on. And it's very important for us. So this is where it's a pact to build a democracy. To build a democracy. That's what the Constitution is, right? It's an agreement, it's a proclamation of intent to build a democracy, agreed by all the people. What was a society riven along caste and sectarian divisions. That is why the preambular assurance that the Republic would be one which guarantees to its people liberties, dignity, equality of status and opportunity, and fraternity. The preamble to the Constitution did not originally contain the expression fraternity. It was inserted later by the drafting committee under the chairmanship of Dr. Ambedkar. While submitting the draft Constitution, he stated on 21 February 1948 that the draft committee had added a clause about fraternity in the preamble, a very fundamental norm, very fundamental standard of human conduct, fraternity. He had added a clause about fraternity in the preamble, even though it was not part of the objectives resolution, because it felt that the need for fraternal concord and goodwill in India was never greater than now. Remember 46 to 49, India was burning. Trains full of dead bodies were going in and out of Delhi. It was in the midst of that, the fire and smoke of that conflagration that the Constituent Assembly was meeting. So it is never greater than now, and that this particular aim of the new Constitution should be emphasized by special mention in the preamble. Pandit Thakur Das Bhargava expressed a sense of gratitude to Dr. Ambedkar for having added the word fraternity to the preamble. Acharya Kriplani also emphasized on this understanding in a speech on 17th October 1949. Again, I come to the great doctrine of fraternity, which is allied with democracy. This doctrine of fraternity was ignored on day one in Chempakam Dore Rajan. It was ignored on Chempakam Dore Rajan and A.K. Gopalan were only 10 months apart, 10 months and a few days apart. Same benches except Justice Vivian Bose joined Chempakam Dore Rajan because he was appointed, he was not yet appointed for when A.K. Gopalan was considered. So they missed the whole idea of fraternity, which is at the heart of democracy. Democracy is basically an attempt to create a fraternal society based on these values. The great doctrine of fraternity, which is allied with democracy. It means that we are all sons of the same God, as the religious would say, but as the mystic would say, there is one life pulsating through all of us. Or as the Bible says, we are one of another. There can be no fraternity without this, end quote. This vision became the dominant vision of the Constitution because the diverse members of the Constituent Assembly, with clashing ideas and warring ideologies, unanimously agreed with those who spoke on behalf of the common masses. This is a comment on this, that India can achieve peace and harmony and avoid a repetition of the Holocaust of killing that took place during partition only if India stands on the foundation of a just social order. I would request that we give us a round of applause to Justice Ravindra Bhatt for having written this stirring language into our constitutional law. Because we may not get another opportunity to have this read and to acknowledge its author in our presence. Because this is a profound understanding of the Constitution, the true understanding. It is because of the lack of such an understanding that we are failing democracy. And it's very important for young people like you to understand this. Now, sorry, I'm switching glasses because I have one where I can't see you and one where I can't read. So I have to. I just want to make one or two more points. And that is to say that where do we go from, see, there is only one question that all of law is concerned with. Like all of medicine is concerned with only one question, which is human wellness. Is a human well or ill? All of law, all the work we do is concerned with only one question. Is human conduct right or wrong? If there is no human conduct issue, nothing can come to a court. There has to be a question. Was some human's conduct right or wrong? If the computer system crashes, unless there is a human intervention, you call a technician, you don't call a lawyer. So that's the only concern. Now, how do you decide whether human conduct is right or wrong? You have to have a benchmark. That benchmark is what we call use, J-U-S. Use. Use means it's the right value. It's a standard of standard. It's a right standard. That's why I can say I want just half a cup of coffee, or I can say you're a just judge, Justice Butt, using the same word, because half a cup is the right value of the coffee for me, and Justice Butt's judgment meets the right value for a good judgment. Therefore, I say it is just. So uses basically means the right value. And the word judge consists of two words, yes, use, J-U-S, and decare, D-I-C-A-R-E, decare, D-I-C-E-R-E, decare. It's a Latin word, which means to declare. So a judge is one who declares what the norm, right norm of conduct is. And when that is applied to the facts of the situation, you get a result. If there is the conduct right or wrong, and if it's wrong, what are the consequences? But you need that use. So even when you have a jury system, it's a judge who informs the jury what is the standard they will use to decide whether conduct is right or wrong. That's use. So use plus decare is judge. This is a word that we have to be very familiar with, and we have to meditate upon as lawyers, as law students, and we are all law students basically. Some of us are so dumb that we never leave the academy. We spend our whole life there. Others are very smart. You just need 5 years and then you're out of the academy, but we stay in the academy without leaving. But so we go from the question of law is human conduct right or wrong? The second question is, how do you decide that? You got a benchmark, that's what we call use. And justice also comes from use. J-U-S is the root of justice. And basically what justice means, not to take more time, it means that use which is eternal, long-standing, permanent, unchanging. That's why Sikhs say Sat Shri Akal to each other, right? Sat and Shri are Akal. So that use which is Akal is justice. So justice is a standard of human conduct actually, which when applied gives a result, which we say is a just result because it's been applied according to the right conduct, according to the right norm. So justice, according to me, is a standard of human conduct, which guides our decisions on whether human conduct is right or wrong. So we go from right or wrong to justice as a standard of human conduct based on use as the norm that tells us what is right or wrong. And then we come to judge who declares what it is, lawyers who argue about what it should be. And then we ask the question, where does this rightness, where does use come from? Where does use come from? It comes from society, not from the legislature. The legislature recognizes it, courts recognize it. It comes from society. So a constitution, a document that provides a framework for establishing the nation itself and provides a framework for the struggle over what is right and wrong conduct, which is at the heart of political struggle, at the heart of law. 100 years ago, 200 years ago, it would have been wrong for me wrong for me not to observe rules of untouchability. But today it would be criminal for me to observe the rules or enforce the rules of untouchability. So the norm has changed, the use has changed. So this struggle that we are concerned with, the struggle for democracy is a struggle over what is right and wrong human conduct. Where does that come from? Typically, it came from religion, from scriptures, priests. Then we realize that these people are setting standards that benefit themselves. It's right for me to kill somebody because I'm a priest. But if you touch my little finger, you'll get a death sentence. And so on and so forth. So people got fed up of that and said, no, people want to take over the power of deciding what is right or wrong themselves. That is Swaraj. The ultimate power in Swaraj is to have power over deciding what is right or wrong human conduct. And how does this happen in society? In society, there is a diverse set of views on what is right and wrong human conduct. There is no, frankly, there is no such, see, society is a descriptor of lots of complex human relationships. There is no such thing as a neat, clean society. There are families, groups, each group has its own view. Even within a family, there are different views on what is right and wrong conduct. So this is a huge issue from little babies upwards. There's a big issue on what is right and what is wrong human conduct. There's huge debates on it, huge issue. That's why the legal system exists now to say, okay, we will handle this question, not the religious people. We will handle this in a democratic manner. So we have to draw it from society. We cannot draw it from religion anymore. But we draw it from society through what? Through creating a constitution. So then we have a democratic process where society can put into the constitution what they want. They can argue about what should go into the constitution as the set of values that must bind all of us. So equality, dignity, fraternity, dignity, liberty. Society says we want that. So that's gone into the constitution. The constitution is a bridge between society and the law. Society can influence the law only through the constitution, at the normative level and at all levels. So it provides a discipline. You cannot just go and influence the law because you're a powerful landlord. You have to come through the constitution and through constitutionally authorized processes to influence the law. But what the input into constitution comes from society, the output is into the legal system. And society is a bridge, that normative bridge that connects the norms of society, creates a consensus on what norms should bind all of us, and then it gets applied through the legal system. So in that process of developing a consensus, we usually end up with a compromise, as our constitution is to some extent. We have to use sometimes some broad language because we have to get a consensus. It's nothing short of a miracle for me that Dr. Ambedkar got this Constituent Assembly to adopt this constitution unanimously. I think it was only because of his personality. If you read the Constituent Assembly debates, all complex issues, he would have the last word or no word. And once he spoke, that was it. Everyone would accept it. He was elected by the drafting committee as its chair. He was not nominated by any party as the chairman of the drafting committee. He became a member of the drafting committee, and the drafting committee elected him as its chair because people like Alladi Krishna Swami Iyer and Gopal Swami Iyengar and all these people realized that this man is far more knowledgeable than any of us to do this task. And they treated him with enormous respect. It's a great tribute to the process. So Dr. Ambedkar brought something forward which is a compromise, but that compromise leans towards democracy, towards socialism, towards a preamble. Although it can be interpreted, as we saw in Champakam Dorairajan, as an instrument of the privileged, but it has the potential to be read in favor of the marginalized, in favor of democracy, democratization. But it was not done. That potential existed. In both these cases, I've given you the doctrines and the counter doctrines. Right? It was not done. And there are some shortcomings where the compromise did not reach where it should reach. But we know the intent, the broad intent. Where is this thing going? It's going towards democracy. But it was not done. So how do we bridge society and the Constitution? By, as I said, through a process, an inclusive process. The Constitution creates an inclusive process, and very at the heart of that process, at the heart of the challenge of India is Dr. Ambedkar's prediction that India will be ruled by an oligarchy, and the only solution to oligarchy is representative democracy, where in the executive, the legislature, and the judiciary, you want to have, as an end in itself, regardless of whether it is good or bad, you must have all communities there, must have voice, and what emerges from a consensus of all communities should be the policy of India, should be the path that India will take, not the path chosen by an oligarchy. So these norms come into the Constitution, then they have to be interpreted and converted into doctrines, as Justice Bhatt has done in this judgment. Doctrine of fraternity. The doctrine that this is a compact between people. That changes actually the whole character of understanding of the Constitution in a very profound way. To understand it as a compact between common people, poor people. Not the product of an elite group that imported stuff from Germany and so on and so forth, but as a compact drafted and crafted by poor people, common people. So in order to apply the provisions of the Constitution, we have to develop axioms from the Constitution and doctrines of the Constitution, doctrines and axioms. Those doctrines and axioms, I've given you two doctrines, they then operate on the functioning of the state and society in a very powerful way. Now, where does the society's ideas of what should be the norms that should go into the Constitution come from? It comes from social philosophies, not social philosophy, but diverse and multiple competing, conflicting social philosophies. Particularly one area of philosophy, which is called axiology. Axiology is the branch of philosophy that deals with the question of value. So 100 years ago, we valued observance of untouchability. Today, we value the criminalization of untouchability. So, axiology, what is the process by which values are created? Because norm is a value. How are values created? So, in social philosophy, we have to focus on axiology, particularly, and understand the axiology through which norms are created, developed, put into the Constitution, get converted into axioms and doctrines, and then get applied to understand the Constitution and understand law and get applied. Now, I'll end with this. The problem we have is that after the British have left and after the Pakistan was created, as Dr. Ambedkar predicted, there is only one dominant social philosophy in this country, and that is basically the Indo-Aryan Vedic social philosophy. That's a dominant philosophy. There are actually many other philosophies. Narayana Guru, Phule, Vellalar, Dr. Ambedkar, Periyar, Buddhism, Jainism, many other competing axiologies. social philosophies. But none of them are brought into the process of understanding the Constitution, although the Constitution emerged from them. The Constitution is understood only from an Indo-Aryan Vedic philosophical perspective. Nothing wrong with that. Respect that. It's very valuable, very important, very wonderful philosophy for those who believe in it. But there are others equally wonderful, equally valid. And one problem is, I had another slide, but I didn't put it here. If you look at the evolution of Western philosophy, you see Plato saying that, I'll just read it to you. Plato says that we must value order, social order. That's justice. Justice is basically the maintenance of order. Then when you start coming further down to Aristotle and Aquinas and so on and so forth, you start seeing an evolution of that, moving towards distribution, moving towards rights, moving towards fairness, other ideas, other ways of understanding justice, not simply maintaining order, which was partly because in Socrates' time, and Socrates himself, was basically killed, and Plato was his disciple, and there was a lot of democratic uprising in Greece, and there was a feeling that Greece is becoming, is sinking into chaos and disorder. So for Plato, imposing order and equating order with justice was very important. Here also there is a fear. What happens if these savage masses come to power? There will be disorder. So wonderful as it is, Socratic philosophy or Indo-Aryan philosophy, it has not progressed from the 5th, 6th century onwards. It is still stuck with the obsession with order, which is what you see in Gajendra Gadkar's, Patanjali Shastri's doctrine that if the state claims national security, just let the state do what it wants because we don't want disorder. We are still stuck at the Platonic stage and we have not moved forward towards understanding justice must involve equity and distribution and fairness and equality and so on and so forth, which the Constitution does. So the Constitution led by Dr. Ambedkar is a quantum leap for India. From the 5th century BC dominant social philosophy to a very modern philosophy. And what we are now seeing is a tussle between this constitutional idea, constitutional philosophy and the old Indo-Aryan philosophy. And that is shutting out all other philosophies from being able to inform our understanding of the Constitution. And therefore, one challenge for us going forward is to make our sources of understanding and interpretation of the Constitution much more diverse, in all senses of the word, much more diverse from a religious, gender, ethnic, linguistic, all points of view, to make it very diverse so that it's better informed. And then we will maybe start to find that the Constitution, which is now forced to rest uncomfortably on a social philosophy, the way Indo-Aryan social philosophy with which it disagrees, and therefore it's unstable, has to be put on a more stable philosophical basis by drawing from the huge diversity of India. I had another slide which I'll try to show you tomorrow which shows you the diversity and complexity of our country. So to sum all this up, I think I would like to just say that we have identified the problem we want to explore, which is where did we go wrong? What is the responsibility of the legal system in our India losing its democracy? And then we've started to explore that. I've started to explore that, hypothesizing that maybe this is happening because the constitution is being worked by the judiciary with an drawing from mainly this Indo-Aryan social philosophy, an anti-democratic axiology. And therefore, they can only see the constitution from the point of view of order and the point of view of stopping reverse discrimination and so on. And that's where probably we are going wrong. And now tomorrow, what I'd like to do in these 2 sessions is, I have about, can we just show that last thing, Kshetrajna? I have about 10 areas I've identified, but I won't have time to go through all the 10. I'll probably put it in writing. Looking at social democracy, political democracy, economic democracy, and cross-cutting issues. And I've identified 10 sets of areas where there are doctrines that have come from the Supreme Court which are weakening democracy. And we'll examine those doctrines, because I've now identified their source. Their source is the wrong social philosophy. The wrong social philosophy is informing their understanding of the Constitution, resulting in wrong doctrines. And those doctrines are then harming democracy. Right? So one is religion, the other is gender in social democracy, and the third is pluralism and diversity against homogenization. Political democracy, the struggle between the oligarchy and oligarchs and the Democrats. Then civil and political rights, 19, 20, 21, 22 freedoms, dissent, opposition, misuse of police power, all these things. Safeguarding electoral democracy, safeguarding constitutional governance and administration, and then implementing the constitutional framework for the welfare state. That's been forgotten, sidelined. The Constitution has basically been shut down in terms of its economic vision. They should amend it and just throw it out rather than keep it there and sort of ignore it. Then democratic development model, what does it mean? Economic inequality, everyone says, Piketty and others say that globally and in India particularly, there is today greater inequality than ever before in history. That's very dangerous, very dangerous. So why can't the Constitution be informed, the interpretation of the Constitution be informed about all this, rather than say, these are matters of government policy, we won't touch it. If inequality is something, if freedom is something that is a matter of government policy and we don't touch it, then what is the purpose of an independent judiciary? Right? And then finally, I think the role of promoting rationalism, fighting faith and blind faith and superstition, looking at nonviolence, compassion, and all that. So these are the 10 areas where I think the wrong doctrines are weakening democracy. Wrong constitutional law doctrines are weakening democracy. We have 2 sessions tomorrow, morning and evening. We'll deal with 2, 3 of these. I'll take on, I think, the religious part first, because if there is a challenge, the most powerful challenge, let me put it this way, the most powerful challenge to democracy today in India is coming from religion. So we need to understand that. Does the judiciary, does the Supreme Court have a role in this? In empowering religion to attack democracy? Not consciously across generations of judges, but does the judiciary have a role in pushing democracy back using religion? Something we'll discuss, and then we'll pick up 1 or 2 others. I won't have time to do all of this, but I appreciate having so much time. I was telling Justice Butt that someone from another national law school called me to go and join a panel for about 20 minutes. I remember I was at a very good panel here the other day on EWS and so on. I enjoyed it. But like that, I was given 20 minutes or something. So I said, look, I'm an old man. I've retired from T20. I don't do T20s or anymore, even one ODIs. I only do long form. So I'm very grateful to Justice Butt and Suhasini and Malavika and Raji for giving me an opportunity to discuss these issues in the long form format which you actually say in your write-up. So thank you very much. I'm happy to take, it's 7:30, but if you have any questions for today, if not, we can take it tomorrow. Please ask those. I'm so sorry to have taken up the full time, but I wanted to finish this conceptual part so that I can move into the specific areas tomorrow. Yes, ma'am. Yes. Shall we take a few questions and then respond? Yeah.
Good evening, sir. Thank you so much for the lecture. It was truly enlightening.
Thank you.
And it was like, honestly, the best lecture I've attended in this hall so far. So you left us with a question that why did those two doctrines, Champakam Durai Rajan and A.K. Gopalan, stayed and why are they still staying? Do you think the reason is that we do not have a representative judiciary?
Yes.
Could that be a reason?
Yes, that is the reason. That is the reason. If you had a representative Supreme Court, according to Dr. Ambedkar's vision, you'd have 8 SC/ST judges. You'd have 20 non-Varna judges, Hindu judges. You'd have 5 minorities. And to ensure that they have a voice, you'd have 1 Dvija judge. Now imagine the jurisprudence that would emerge from such a court. They won't have the kind of scholarship that we're now getting, but it'll be something completely new. Like the American courts produced a completely different jurisprudence than the House of Lords. Because they were, many of them were not even lawyers. They were not even, they were not learned scholars. They just went in there and just expressed their axiology. So yes, that is, and of course, in this, I only mentioned the social communities, but within that, we have to have more than 50% as women. We must have regional diversity. We must have linguistic diversity. So we must take diversity seriously, as the US Supreme Court does. When Justice Stephen Breyer retired, there was a consensus in the country, we need a black woman. Because we've had a black man, but we've never had a black woman on the court. Everyone agreed. And they found an array of, when they started to look, they found an array of scintillating black women jurists. And they picked one of them, Justice Ketanji Jackson, who's outstanding. Right? But they required a consciousness of that we don't want another white man. And so today you have 4 women and 5 men, right? But the conscious awareness of the need for diversity and the need to bring plurality is something that here is anathema. We cannot talk about this because if we talk about it, it hurts the oligarchy, their interests. So it's taboo. But I agree with you. Thank you. Where are you? If you can put up your hand. Oh, yeah. Thank you so much. Oh, sure. You need to go. Okay. So what I suggest is we can end the formal session here. Those who want to ask questions can stay, and the others can, if with your permission. I don't want to take over the thing. Because if there are people who want to ask questions, I'm happy to answer them because we may not get time tomorrow to deal with these questions. Because I have a big agenda tomorrow. Because I want to take you through some very specific cases and issues. Is that okay? So maybe Suhasini, you should end this and then I'll stay here.
I think I can speak for all of us. Thank you so much, Professor Gopal. That was a truly, truly illuminating lecture. And this is the kind of lecture that I think I hoped that I would have had when I was in NALSAR so many years ago. But I'm really happy that now today's students are getting to do this. And I just want to say one thing before we end for today. Like Professor Gopal said, anyone who wants to stay back and ask questions, you're most welcome to do that. Everyone else can go for dinner. But I want to tell all of you to be interactive in this session as much as possible. I want you to truly engage with the themes that Professor Gopal has raised and challenge them if you feel that you don't agree, because I think that it's very important to have good academic discourse and debate. And I'm happy that somebody asked a question today, and I hope that going forward, you guys will make your voices heard as well, because that's what we are hoping the center will do. We want to foster an interest in constitutional law. We want to understand how you view constitutional law, and we want the benefit of academics of such eminence as Professor Gopal to guide us and shape our thinking and help us discuss these issues. So I hope you guys will keep that in mind for the 2 sessions going forward tomorrow. Thank you, everyone. Thank you to the VC. Thank you, Justice Butt. Thank you to my colleagues. We'll see you guys tomorrow. We are all 3 of us, Malvika, Raji, and I are here if you guys have any other questions or any housekeeping issues to raise with us. Thank you. Good night, everybody.
Now, good morning, everybody, from me. If whoever wants to stay, and ask questions, I'm happy to answer. I hope for you, it's okay to stay for a few minutes? Yes. No, I think it's better then people can see and, let those who want to go. Yes, please, yes. Is the solution acceptable to you? Yeah.
Evictees, so my question
Yeah.
stems from this. Hello. Sir, my question stems from this idea that you have placed how the Indian state is not being operated upon by the will of the people. It's being
Operated upon by?
like the Indian state,
Yeah.
a lot of its mandate and its effective governance is coming from this.
Yeah.
So
It's okay.
So,
Go ahead. Sorry. Just so as not to delay
yeah,
the
okay.
questioners. Yeah.
Ma'am just suggested that I should wait for a second.
Okay. Let it settle down. Yeah. Sure. Okay. Yeah. I thought it was in the afternoon, no? Oh, it got postponed. Okay. Yeah. Someone asked me to join. Yeah.
So,
Yes.
so my question comes from this position is that the Indian state has not been well represented enough.
Correct.
In order to effectuate a more representative government policy as such, resulting into the oligarchy of communities that we have.
Yes.
So, as your understanding puts a lot of the blame on the judiciary and it not being represented as such, a problem which I see and I want to inquire your views on the same is that in India's electoral system, what we effectively has is that we have to form coalition of communities where communities such as Dalits and Muslims and those who are in the lower strata of the community are forced to effectively give their support for the less worst of the options and have Brahmins and top community leaders elected on their vote share because on its own their vote share would not have such value. And then they are forced into these coalitions where they're not well represented, their demands are not well represented. As we have seen, such a committee report for matter, and that logic can be extended to Dalits and other communities as well, is that their vote is being represented just there for the security of sake. Had it been a different form of representative system where the community's voices were more reflective in the term of what their population is, per se. In those instances, do you see the Indian state's policy being more different and more representative? And can a solution to the problems that we see today, they lie only in the judiciary, or some sort of a change in the electoral system itself needs to be undertaken?
No, I I think you've stated the issue better than I did, very clearly, and I agree that if we want to regain democracy, Dr. Ambedkar said there are two parts of. He said electoral democracy, responsible government, we all want, but the depressed classes of this country want representative democracy. He said this in 1930, very strongly. He presented a memorandum to the 1930 Roundtable Conference, which must be, in my view, one of the starting points of a course on constitutional law. The papers he pressed, because it was a constitutional conference to decide on the 1935 Act. So there he said, we want representative democracy. So neither he nor you nor I can predict where this will take us. But we want it. It's like the American Revolution started off with a slogan, no taxation without representation. They didn't know where it would take them. They just said, look, we don't want to be ruled by people, by other people without our representation, right? So we are at that stage where, according to Dr. Ambedkar, we must fight for adequate representation. And when we have a representative judiciary, then that judiciary will be familiar with, like the great judges like Justice Gajendra Gadkar, Justice Patanjali Shastri, Justice B.K. Mukherjee. Tomorrow we'll discuss some of their judgments. They, not because they are casteist or communal or anything like that, their whole life experiences with only a small set of doctrines and philosophies. And so if you're a constitutional, if you're a Supreme Court judge and you're asked to make normative judgments, like is it right or wrong for Brahmins to be given only 2 seats in the Madras medical colleges, right? Where do you go seek for guidance on whether this is right or wrong? You are actually turning to your social philosophy, because the Constitution itself does not, does not have clarity on that. At that point, especially, there are no constitutional doctrines. It was only a few days into the Constitution, few months. So then you draw on that Constitution and you reflect that and you say, yeah, then you turn this whole provision into a protection of reverse discrimination. Totally opposite. You've flipped Article 15 on its head, and it cannot be reversed even now. So, but when you have a critical mass, not just the odd SC here or odd SC there, but if you have critical mass of 8 Supreme Court judges, 20 non-Varna judges, 5 minorities, reflecting, as I said, gender, regional, linguistic, all this diversity, then I think we'll start to see a different jurisprudence that will take forward the vision of the Constitution. Today, the doctrines coming out from the Supreme Court in these areas, not in all areas, but in these areas, are weakening our democracy. We must know that. Yes. Questions? But thank you for that suggestion. It's a very constructive suggestion that we end and then leave it to those who ask questions. Yes, sir.
Good evening, sir. Thank you for this lecture. It has been lovely. It has been a lovely lecture. You posed 2 questions. What is the Constitution? And when we talk about the Constitution and separately, and we cannot talk about separately about it without bringing in the courts. But to me, lately, like for the moment I've been alive, for me, any court has been the same archaic sense a monarch would be or a church would be. And Supreme Court can be no exception to that. I feel that Supreme Court is highly in disconnect with our public realities. How are we living? How are we doing? The Supreme Court doesn't understand. I, as a student of the law, I'm a first year student. I might be totally out of place here, but
First year student?
yeah.
That's very good. You've got a fresh mind. So that's
so I might be completely out of place, but the terms we use in a simple 5-page bail judgment is so out of connect with me that I don't feel that our judiciary is evolving. Like it is in disconnect with our abilities to think. And I think it is, I might be completely wrong, I think because we are not making anything on our own. We have copied it all from Canada and UK and America and whatever Commonwealth we have. But if we deny ourselves to be a part of this Commonwealth, why should we not just scrap it all and create something fresh that represents us? Maybe that will solve the question you put about representation.
See, what what I want to ask you is, I mean, that's a very valid point of view. It's a very recent point of view. But what I want to ask you is, why didn't Ambedkar say that? He's never said that. Now, he came from the most excluded levels of society. He became the chairman of the drafting committee, but nowhere did he say that we should scrap this whole thing and dream up something new. It's not so easy to dream up something new. So we must understand. It's like saying I go to medical hospital. They're all the same. I go to the emergency room. There's the same old thing. They'll write up something. They'll give me some medicine, right? So somebody may say, why don't we, none of this is working. Why don't we scrap this whole thing and set up a completely different health system, right? But there's a science behind it. In the same medical room, if there are 3 doctors working, each of them is working in a different way. Understanding their the diagnosis and their response in different ways, understanding their science in a different way. But the difference between legal education and medical education is they're all agreed. It should be the same with lawyers. That's why we'll talk, if we have time, a little bit tomorrow. They follow the same methodology of thinking, because we know that's a safe methodology. What is an operating theater? It's a site of struggle to save a life between some viruses, some damaged body parts, and medicine. Constitution is a site of struggle between good conduct and bad conduct, right? So we cannot just go in there and just say, okay, let's just sit here and say, okay, what's your problem? I'll give you, justice. That can be done, and we are doing that. We have Gram Panchayat and mediation and all kinds of places where that's done, where there is no normative issue. The quarrel is simply about, sometimes it's simply you just need a good calculator, so I hit into your car, and I calculate the damages as 1 lakh, you calculate it as 1.25 lakhs. There's no need for us to go to a court. It's a question of how do you assess damages, right? So you just need a good accountant or a good insurance person to do that. But if we have to get into the question of were you driving negligently, then we have to have a standard of definition of what is negligence. Otherwise, you'll go to one room, you'll get one standard, another room, you'll get another standard. So we have to somehow ensure that there is some consistency in how negligence is defined. And then what punishment I will get if I've knocked into you and they find me guilty of rash and negligent driving, then what should be the right punishment, right response to that, right? So we want to have norms which are clearly understood. We want methodologies to understand and apply those norms as fairly as possible. When I was director of the National Judicial Academy, and I don't speak publicly about anything I did there, but Justice R.V. Ravindran has written about this, referring to the National Judicial Academy in his book. Justice R.V. Ravindran has written a book. So I can speak to that extent because he has made it public, but we did simulations. So I actually started with asking him one day, and Justice S.B. Sinha, why is it that judges give so many different judgments or similar situations? They said it's because facts are different. So I said, shall we try that out? They said, sure. So we got a big room of experienced judges. We had some, 2 young professors argue a case before them. Facts are the same, arguments are the same, heard at the same time. We got 60% conviction, 40% acquittal. Right? Then I started to do this further. Then I realized that if I change the simulation, I can get 100% agreement, unanimity. Or why does it go from 50 to 100? Because when I put a frame, I frame a simulation where the answer depends upon raw social philosophy. For example, a simulation where a son, an arrogant, prosperous son, kicks his mother out of his house and she's on the street. 100% of the judges will find a way to say, no, you have to put her back there and treat her properly. There will be no 60-40. So when there is the social philosophy and social values are shared, then you get very similar outcomes. Because morality, what we're discussing, right and wrong conduct, is a very social, social issue. So how do we ensure that there is equal justice under the law? The US Supreme Court, on top of it, is written equal justice under the law. Otherwise, whether I get acquitted or convicted depends on which judge I'm placed before. So we want to get away from that. So Justice Ravindran, very honest, very candid, very open judge, he writes about this and he says the way to tackle this is by doing what the academy is doing, by improving our ability to, that's why I put here method of thinking, that we must think rationally. What I said about Justice Butt, when he has told me when he writes a judgment, till he concludes a judgment, he himself doesn't know where he's going to reach. Because he's taking the law, he's looking at the law from a very systematic point of view, using established law, established interpretation, and he's letting that logic lead him to a conclusion. Right? So that methodology, that's what you're here to learn. The way to think like a lawyer. Now, those who are not lawyers may find it tiresome. But that's the only way, and we have to be constantly critiquing that, as we are now doing. I'm basically saying that lawyers and judges, and I blame not just judges, I blame the lawyers who argue before the judges. Because they're also putting before them a lot of this very regressive ideas and not maintaining this rigor. I'm sure I've seen and admired a lot of the judgment. You'll never find a judgment of Justice Ravindra Bhatt that does not draw from the constitution or legislation or established precedent. Now we are bypassing the constitution and reaching directly into society and drawing norms from society. We'll see some of that tomorrow. And then that's basically overthrowing the constitution. However you love a norm, it has to go through the process of even basic structure. Justice Kapadia's approach to the basic structure was that you cannot accept anything as basic structure unless it has been already accepted as a principle in international law, in constitutional law. So you can only, first there's a filter that you take an idea, an argument, a doctrine, then you elevate it to a part of constitutional law by a constitution bench, then you see whether you want to promote it as a basic value, right? So there's a discipline there, which is, I think, very important. Justice Bhatt is a first-year student who was asking, why can't we just wind this whole thing up and just start afresh? So I was saying that, look, my question was, why didn't Dr. Ambedkar suggest that? Because he knows that this is a very complex problem that we are trying to solve, and we have to have a methodology for it. You have to think like a lawyer. Anyone else? Sorry? Yeah.
Hello.
Yes.
Sir, here.
Yeah.
Yeah, sir, good
Yes,
evening,
yes,
sir.
yes. Good evening, good evening.
So when you said that like we need to include diversity in our judiciary, we have an underlying recognition of the fact that
And the bar, and the bar, and the bar.
at the bar.
Yeah, just
So-
if you have an oligarchic bar,
Mm.
having a representative judiciary is not going to make much of a
Yeah.
difference.
So-
And representative legal education and faculty. All this is one group of people, right? Yeah.
Yeah.
One community.
Yeah. So when we say that, we make an underlying recognition of the fact that the people who sit on the bench have their own individual politics and their own individual,
No.
their own individual interpretation of the law.
No, what they're saying is, I'm saying that in the law, you draw upon philosophy, social philosophy.
Yeah.
I'm raised like that. I have my own social philosophy. It's not because I'm prejudiced, but I'm raised by, to have certain influences. So I have to cultivate the methodology of a justice, but to overcome that,
Okay.
a discipline. So I will see a case and I'll want to. Yeah. So what I'm saying is I'm sure there are judges who have that, but in my experience, that's not the problem. The problem is we need bona fide judges who have been brought up in diverse ways and who will therefore have different social philosophies. So when they talk to each other, like, why did Justice Butt invite me to give this lecture? Because he wanted to hear something different. Justice Butt is very keen always, not that he'll agree, but he's always very keen to hear something different, right? And when we hear something different, then it gives us some opportunity, some material to think and reflect, right? So we want diversity because we'll have, like having, why is it important to have women? Because they have a different life experience.
Yes.
And you'll be able to think, the institution will be a much better quality institution when you have diversity.
So, but there is a popular conception of law being objective, and whosoever sits on the bench is like he aspires is in law aspired to like interpret the law in an objective way, as to it doesn't matter if a woman sits or a man sits, there needs to be an objective interpretation of law. How do you see that? Like,
See,
there needs to be a demolition of that myth.
Very
for-
good question,
For
yeah.
this to come in.
Very good question. When we say objective means based on the object, right? Not on the subject, but on the object. So that's where methodology comes in, right? So to be objective is a methodology. To be logical is a methodology. It's a way of thinking. Logic is simply a way of thinking, right? So I found in my experience doing these simulations, which Justice Ravindran has written about in his book, some of our NGA simulations. I still don't say a word about anything in the academy, but what he has written in his book, I talk about because he has written about it. So what I found, I was saying earlier, is which he hasn't reflected, but I am saying, because he reflected that we in the simulations we got big diversity and big difference with the same facts and the same law. It's true, but what I was telling them, but we've also got is, I've also got huge agreement, 100% agreement in simulations. And then I realized, and I gave the example, if you give a fact pattern where there is a complete consensus in society, you'll get 100% agreement. Because the social philosophy, the axiology is shared. So I gave the example of a powerful, arrogant young son throwing his helpless mother out on the street and saying, get out, and take him, my house belongs to the mother, throwing her out. There's not a single judge in this country who will not give relief. So therefore, we understand that when there is no shared axiology, no shared norms, there are conflicting norms, then you'll get a lot of diversity. And there the objectivity will start to go down. Even methodology may not be able to overcome that because it's very polarized. So how do you handle those hard cases, not the easy case? Justice Barak also talks of hard cases and easy cases, right? So the hard cases are the tough ones. And the hard cases, he doesn't talk about that, but I think in a country like ours, which is so diverse, the only way to handle that is to have diverse points of view. Diverse in every respect, not simply so-called castes, but ethnicity, gender, economic class, background, all kinds of life experiences so that people can sit together. Justice Sonia Sotomayor of the US Supreme Court, she almost didn't get a job because when she was a judge in the Court of Appeals, she made 4 times she spoke saying, I am a poor Puerto Rican woman. I grew up in the poor parts of New York. And I become a judge now. I am a better judge than a white man, she said. So the senators and the White Bar Association and the white judges got upset. What do you mean you're a better judge? Say you're a good judge, but how can you say you're a better judge than a white man? She refused to back down. She said, because I have experienced discrimination as a woman, as a Puerto Rican, as a poor person, that they haven't. Now, the good judges, I have not experienced deprivation as a woman or as a poor person in this country. And I cannot hope to, my views will never reflect that experience. But what can I do? I can't seat someone near me who has got that experience and listen to that person and give that person's view equal value. And for me, that person is Dr. Ambedkar. And I read him a lot. I understand, I try to understand what he does because he has a life experience that I don't have. And his perspectives had huge value to my own very limited life experience, right? So I think these are complex questions. Take it within a family. If you want to decide a normative question in a family, is it right for my brother to have slapped my sister? Or is it right for my brother to marry outside the community, right? It's a difficult question to answer, right? You want to maintain those family bonds, but you want to maintain traditions. What will people think? So what's the best way to resolve these moral questions, right? Which are very complex. Basically, it's to get a lot of people involved and have a lot of dialogue and conversation, talk a lot about it, understand each other. When I was in the National Law School, Bangalore, I actually had an example. And recently I saw a piece written by someone involved there. The driver of the Vice Chancellor from Dr. Menon's time was a Muslim. And he had a daughter. And he continued as the driver when I was there also. He had a daughter. The daughter fell in love with a Hindu boy who worked for another professor, this research center. And they were sincerely in love with each other. And families wouldn't agree. So they eloped. And when this happened, the concerned Muslim colleague and his family and friends got extremely agitated and came to me. I was then the director and said, you have to, we want to find him and we want to, whatever. They were very angry with him, very angry. So then I talked to him. I said, let's talk about it. I said, I'm a father of 2 girls. You have a daughter. You and I know how precious this relationship between father and daughter is. I'm not saying mother and daughter is not precious, but I don't know that relationship. I know the relationship between father and daughter. I don't know the relationship between father and son. I have no son. But this I know. And I said, I know that I cannot survive even for a second if that relationship is terminated. So I said, if I were you, my only concern would be, I have to maintain my relationship with my daughter for my own survival. And for that, what do? You find out what your daughter really wants and do what she wants. Then he thought about it. He said, okay, but he must convert. I said, look, if you believe in God, Allah, let Allah decide whether he should convert. Why should you decide that? You should not force someone to make an insincere conversion. Long story short, they all consented. They got married on the premises of the National Law School. Later, this gentleman, the father, he got cancer and died. But that son-in-law and that marriage is not only very happy, that son-in-law is looking after the whole family. It all simply happened because we talked to each other, tried to understand each other. That's what good judges do and good mediators do. Just get people to talk. So we have a lot, we know all this. None of this is rocket science. The problem happens even in the judiciary when people come in with very narrow perspectives and they just ram their perspective through. Then you've got all kinds of, you got ADM Jabalpur and so on, right? And but when people talk to each other, that's democracy. Means democracy is a conversation between people, basically equal, free. So that's a cultural change. We need to democratize the society. The judiciary, I believe, is only a mirror of the legal system. The bar and the bench are only a mirror of society. The bench and the bar of Kerala is very different from, as Justice Bhatt knows, very different from UP and Bihar bench and bar. It's a mirror of society. So only when we democratize society will the legal system get really democratized. And all the trouble in this country is actually taking place over the issue of how to democratize the Hindu social order. And Hindus themselves are divided about it, on whether to do it and how to do it. It has happened more in the south than in the north. But in the north also, lots of people are in favor of it, that we want democratic social order, right? So it's a tough struggle, but we must talk to each other, not otherize each other and make enemies of each other. Appreciate each other, understand each other. As they say, men are not on Mars and women on Venus. We are all on Earth together. We have to talk to each other. But thank you for a very good question. All the questions have been good, yeah. Anything else? Okay, so then, oh, one question up there. Yes, ma'am.
Hello, sir. First of all,
Yes.
thank you for coming here and delivering the lecture. It was a wonderful lecture, I must say.
Thank you.
My question is, you talked about talking in a democracy. Like the
We
voice,
talked about
you talked about how important talking is, conversations,
talking, conversation.
in democracy.
Yeah,
India is a linguistically diverse country.
yes.
Then how can I talk to like somebody whose language I don't understand? So that is also like linguistic diversity is a question which often arises in my mind when I talk about democracy in India. Because for there to be a people, for there to be a democracy, there must be conversations happening throughout the country.
Right.
And like if I do not understand somebody, how can like we as a people rule ourselves? So yeah, that's my question.
It's a very good question, and I think I'd say two things. One is that we have had this problem since the earth was created. No, we've all been living next to each other. In fact, we now can talk a little more than before, because earlier you traveled 20 kilometers. I remember some judges from the hills saying that they cannot talk to people who live like 20 kilometers on the other side. But now, gradually, we have developed common script, like Malayalam common script. There's a great Malayalam intellectual called Eഴുത്തച്ഛൻ. Ezhuthu means writing, Achan means father. So he's a father of Malayalam script, Eഴുത്തച്ഛൻ, Tunjan Eഴുത്തച്ഛൻ. So he developed a common script. And so we've made a lot of progress in finding the tools to talk to each other. And I feel within another 5-10 years, I'll be able to just put something in my ear. You can speak in any language you want. I'll listen to it in any language that I want. It's already possible with my phone. When I travel, all I have to do is to put the phone to someone, they speak in their language, and I look at the phone or I hear it, and I hear it in my language. Right? So technology is helping solve that in a very nice way without destroying any language. And because I think that if we are determined to talk, then language will not come in the way. Never comes in the way. We'll find a way to talk and communicate. We always do. The second thing is, look at the European Union. There's no common language. There's no Hindi. Common language is not Hindi. They speak very different languages, right? but they're doing pretty well, right? They're finding ways to talk to each other. If they have to go somewhere, they learn some language and they'll talk, learn a few words. So I think what the real barrier is that we must have a strong intention to talk and understand that conversation, dialogue based on equality, based on dignity, based on mutual respect, based on fraternity, based on the liberty. On those normative foundations, we must all talk to each other as equals. Once that resolve comes, then language, I think, is a big problem, but it is being solved. I think it's not going to be such a big obstacle in future, hopefully. But thank you for reminding us of that obstacle. So thank you very much for a very interesting set of questions, and thank you for staying back. We'll see you at 11:30 tomorrow. 11:30 tomorrow. Okay. Thank you so much. Thank you.